This video is a continuation of our discussion on the crime of direct assault, but for this video, we are going to discuss this time direct assault of the second form. We are also going to talk about qualified direct assault and direct assault complexed with other common crimes. Article 148, direct assaults. Any person or persons who, without a public uprising, shall employ force or intimidation for the attainment of any of the purposes enumerated in defining the crimes of rebellion and sedition, or shall attack, employ force, or seriously intimidate or resist any person in authority or any of his agents, while engaged in the performance of official duties, or on occasion of such performance, shall suffer the penalty of prison correctional in its medium and maximum periods, and a fine not exceeding 200,000 pesos. When the assault is committed with a weapon, or when the offender is a public officer or employee, or when the offender lays hands upon a person in authority. If none of these circumstances be present, the penalty of prison correctional in its minimum period and a fine not exceeding 100,000 pesos shall be imposed. As you can see here, the underlined portions, the first underlined portion, refers to the second form of direct assault. And the second underlined portion found at found near the bottom of this article or provision are the circumstances which qualify the crime into qualified direct assault. That is when the assault is committed with a weapon, or when the offender is a public officer or employee, or when the offender lays hands upon a person in authority. And the last sentence of this article refers to the penalty to be imposed. The crime is only simple direct assault, whether of the first or of the second form. Now, let's go to the elements of the second form of direct assault. Number one, the offender here makes an attack, employs force, makes a serious resistance, or makes a serious intimidation. Second element, the person assaulted is either a person in authority or an agent of a person in authority. Third element, at the time of the assault, the person in authority or his agent is engaged in the actual performance of official duties, or that he is assaulted by reason of the past performance of official duties. Fourth element, the offender knows that the one he is assaulting is a person in authority or an agent of a person in authority in the exercise of his duties. And last but not the least, number five, there must be no public uprising. We will dissect each of these elements in the succeeding slides. So please take note of the five elements. Let's go back to the first element. What does the phrase shall attack, employ force, or seriously intimidate or resist mean? When you say shall attack, it means an aggressive and violent action against a person in authority or against an agent of a person in authority. For example, X approaches Y. Let's say Y is a person in authority, then hits the latter's face with a baseball bat. This is an example of an offender attacking or making an aggressive and violent action against a person in authority or against an agent of a person in authority. What about the phrase employ force? The force employed under the first element must be serious or must be of a serious character when it is against an agent of a person in authority. Hence, if the force employed against an agent of a person in authority is not of a serious character, then the crime will only be the crime of resistance and disobedience under Article 151, not direct assault under Article 148. Again, with respect to the degree of force to be employed against an agent of a person in authority, the degree of force must be of a serious character. Example of force employed which is not of a serious character. Let's say X, while being arrested, tried to resist the arrest by punching the policeman in the breast, as ruled in the case of US versus Tabiana. What this means is that the degree of force here, according to the court, while it is admitted that the offender punched or hit the policeman in the breast with the use of his fist, in that case, the Supreme Court did not consider the degree of force employed serious enough to constitute direct assault. The crime committed by X here is only resistance and disobedience against an agent of a person in authority. Here is an example of when the force employed is of a serious character. X, Y, and Z seized a policeman by the throat, threw him to the ground, and struck him several times with a club. Here, the actions of X, Y, and Z indicate a determination to defy the law and its representative. Who is that representative of the law? The policeman. The crime, as ruled in the case of US versus Cox, is that of direct assault. Now, if you compare that with the previous example, there is a whale of difference between the two because in that first example, the offender merely hit or punched the policeman, hitting him in the breast. But in this example, in this particular case, the three accused did not only threw the policeman to the ground or grab him by the throat, they struck him several times with a club. All three of them, no, taking turns hitting the policeman with a weapon or with a blunt instrument. The court in that case ruled that what happened or what the accused did was not merely a case of resistance and disobedience, but a case of direct assault under Article 148 of the Revised Penal Code. Take note, however, that when the offended party is a person in authority, the force employed need not be serious. Again, here lies the distinction. When the offended party is an agent of a person in authority, the force employed must be of a serious character, but not when the offended party is a person in authority. Take note of that. Example, slapping the face of a person in authority while the latter is engaged in the performance of his duties constitutes direct assault. Reason? It is expressly provided that the mere laying of hands against a person in authority already constitutes qualified direct assault even. Why? Because in Article 148 itself, it is expressly stated there that laying hands upon a person in authority increases the penalty to prison correctional medium and maximum period. In continuation with our discussion of the first element, You must remember that there are four ways by which the assault against a person in authority or his agent can be committed. We have already discussed the first two. That is when the offender makes an attack or when the offender employs force. There are two other ways under the first element. Direct assault can also be committed when the offender makes a serious intimidation or when the offender makes a serious resistance. And also take note that the intimidation or resistance must be of a serious character, whether it is against a person in authority or against an agent of a person in authority. So let's start discussing the third way by which direct assault is committed under the first element. Again, the resistance must not only be serious, it must also be active, not a mere passive resistance. This is an example of a resistance which is not of a serious character because the resistance is only passive resistance. X tried to resist arrest by throwing himself to the ground, forcing the police officer to drag him towards the police station. Here, there is only passive resistance. Why? Because the offender did not actively resist by shoving the policeman or refusing by punching the policeman whenever the policeman attempts to arrest him or bring him to the police station. In this particular case, the offender merely threw himself to the ground, forcing the police officer to drag him towards the police station. And the court in this case or in that case considered only the resistance as passive. And as I've already emphasized, the resistance must not only be serious, it must also be active. Hence, the crime committed is only resistance and disobedience under Article 151. Now, here is an example of a serious resistance that is a perfect fit under Article 148. In the case of U.S. versus Samonte, when the policeman was about to arrest X, the latter tried to strike the policeman with a knife or tried to deliver a stabbing blow to the policeman, but the policeman did not get hit. That is an example of a serious resistance, which can come or which comes under Article 148 of the Revised Penal Code. As to the fourth manner by which direct assault can be committed under the first element, the intimidation directed at the person in authority or an agent of a person in authority must not only be serious, it must produce its effects immediately. Example, X pointing and aiming his gun at the fiscal who filed a criminal case against him constitutes serious intimidation. Here, the intimidation is immediate and apparent, not a mere threat to do some future evil. Why is it immediate and apparent? Can you just imagine a person pointing a gun at you? There is nothing more immediate and apparent than that. You are, at that point in time, or the fiscal or prosecutor in this example, at that point in time, is at the mercy of the offender because the offender might at any time pull the trigger of his firearm. That is why, in this example, the intimidation made against the prosecutor when the offender pointed and aimed his gun at him is considered immediate and apparent, not a mere threat to do some future evil. Let's go to the second element. The second element requires that the person assaulted must be either a person in authority or an agent of a person in authority. Who then is a person in authority or PIA? A person in authority is a person directly vested with jurisdiction, whether as an individual or as a member of some court or government corporation, board, or commission. This definition was taken from Article 152 itself of the Revised Penal Code. When you say directly vested with jurisdiction or a person directly vested with jurisdiction, it means the power and the authority to execute the laws. Examples of persons in authority: governors, vice governors, mayors, vice mayors, members of the sanggunians, the Sangguniang Panlalawigan, Panglungsod, and even the Sangguniang Barangay. These officials or these public officers are clearly and directly vested with jurisdiction to execute the laws. They have the power and the authority to execute the laws by virtue or by the very nature of their positions. Other examples of persons in authority are the public and the private school teachers and lawyers in the actual performance of their duties. But they are only considered as persons in authority for purposes of Articles 148 and 151. Other than that, they are not considered as persons in authority. Now, how do we differentiate the first example from the second example? The first example, I am referring to the governors, vice governors, etc. They are considered as persons in authority regardless of whether we apply Article 148 and 151. Why? Because by the nature of their functions, they are given the power and the authority to execute the laws full-time. Other examples of persons in authority are the heads of executive departments, the judges, and the fiscals. They are also vested with the authority to execute the laws. What about agents of a person in authority or agent of a person in authority? He is a person who, by direct provision of law or by election or by appointment by competent authority, is charged with the maintenance of public order and the protection and security of life and property. This definition was also taken from Article 152 of the Revised Penal Code. Examples of agents of a person in authority: barangay tanods, members of the PNP. I am referring to our police officers, NBI agents, PDEA agents, BIR and customs agents, soldiers, municipal treasurers, the postmaster, the sheriff. These are just some examples of agents of a person in authority. An agent of a person in authority can also be any person who comes to the aid of persons in authority. Again, take note of the wordings. Any person, whether a public officer or a private individual, if he comes to the aid of a person in authority who is being subjected to direct assault or who is being attacked by an offender, and that person comes to the aid of such person in authority, meaning he intervenes by helping the person in authority, that person who comes to the aid of such person in authority will be considered an agent of a person in authority under article or as stated or as so provided in Article 152 of the Revised Penal Code. Third element, that at the time of the assault, the person in authority or his agent is engaged in the actual performance of official duties, or that he is assaulted by reason of the past performance of official duties. Here are some examples of actual performance of official duties by a person in authority or by an agent of a person in authority. In the case of People versus Teves, X elbowed the provincial governor while the latter was going down the stairs of the building. The governor at that point in time was inspecting the office of the chief of police. Klaro-klaro na the governor was in the performance of his duties because he was inspecting the office of the chief of police at that time as part of his duties as provincial governor. Another example, X attacked the barangay captain who reprimanded him for ungentlemanly behavior during a public dance held in front of the store of the said barangay captain. Why did the barangay captain in this particular case of Peeper versus Jalit reprimand X? He reprimanded X because several women complained to him about the, as I said, the ungentlemanly behavior of X. Now, even if the barangay captain was clad in an undershirt at that time and he was just inside the store when he reprimanded X, in that case, the attack on the person of the barangay captain was deemed made on the occasion of the performance of his official duties. Here is another example of when a person in authority or an agent of a person in authority is deemed to be in the performance of official duties. Take the case of a fiscal who was attacked while on his way to the office to conduct an inquest investigation. Again, take note that he was assaulted not when he was already conducting an inquest investigation, but he was attacked while he was still on his way to the office where he intends to conduct an inquest investigation. The Supreme Court in this particular case already considered the fiscal's act of going to the place of his work as in the performance of his official duties. Now, here are some examples of situations where a person in authority or his agent was not deemed to be in the actual performance of his official duties. In the case of People versus Hinko, a teacher who went out of his classroom to talk to his creditor about his unpaid accounts was deemed not engaged in the performance of his official duties as a teacher. Hence, if on such occasion the teacher is assaulted, there is no crime of direct assault. But it doesn't mean that there is no crime committed. Yes, there is a crime committed, only that the crime is not direct assault. And what crime could that be? The crime could be either physical injuries, attempted homicide, attempted murder, frustrated homicide, frustrated murder, as the case may be, but not the crime of direct assault. Another example, in the case of People versus Seda, a policeman who fetched his daughters from a dance party and while on the way home, he was ambushed. Here, the policeman was not on his way to work. The policeman was on his way going home from or after he fetched his daughters from a dance party. So, klarong-klaro dito na the policeman was not in the performance of his official duties, although he is a policeman, but at that point in time, his purpose in going to a place where his daughters were is not related to the performance of his functions as a policeman. It is related to the performance of his functions as a father to his daughters, but not to his functions as a policeman, such that upon going home, he was assaulted or he was ambushed. The ambush made on the policeman by the offender was not deemed direct assault, but for some other crime. Another example, when the persons in authority or their agents descended to matters which are private in nature, an attack made by one against the other is not direct assault. What's the key phrase here? Their argument boiled down to matters which are private in nature, totally not connected or unconnected or totally not related to the performance of the functions of a person in authority or his agent. Another example, when the person in authority or his agent exceeds his authority and violates the rights of a person, he will not be deemed to be in the performance of his duties. Take note, in this particular example, the person in authority or the agent of a person in authority exceeded his authority as such. He not only exceeded his authority, he likewise violated the rights of the person concerned. In such a case, he will not be deemed to be in the performance of his duties, and such person may resist the invasion of his rights, and if in the process of repelling the aggression, he lays hands on the person in authority or his agent, there is no crime of direct assault. Take note, however, that the resistance must not be greater than what is necessary to repel such aggression. This is called self-defense in direct assault. Well, technically, or not technically, while physically, we can say, that the person here is assaulting a person in authority or his agent. In reality, he is not assaulting the person in authority or his agent, but he is only defending himself because the person in authority exceeded his authority and violated his human rights. Now, how do we interpret the phrase on occasion of such performance as stated in Article 148? When you say on occasion of such performance, it means that the motive or reason for the attack on the person in authority or his agent is or was the performance of official duty. Here, a person in authority or his agent is assaulted by reason of the past performance of official duty, even if at the very time of the assault, no official duty was being discharged. So, please remember that to constitute direct assault, it doesn't always have to be that the person in authority or his agent is in the actual performance of his official duties. Even if the person in authority or his agent is not in the or was not in the actual performance of his duty at the time of the assault, but he was assaulted by reason of the past performance of his official duty, then the crime of direct assault is still committed, as ruled in the case of Justo versus CA. Fourth element, the offender knows that the one he is assaulting is a person in authority or his agent in the exercise of his duties. Why is this fourth element important? This fourth element is important because absent such knowledge, it cannot be said that the offender intended to disrespect the law or defy the person in authority or his agent who are visible representations of the law. But there must be proof that the offender actually knew at the time of the assault that the person he is assaulting or that the person he assaulted is either a person in authority or an agent of a person in authority. Fifth and last element, there must be no public uprising. Because if there is a public uprising and if the same be tumultuous, the crime will no longer be direct assault but the crime of sedition. When the purpose of attacking the person in authority or his agent is to prevent him or was to prevent him from freely exercising his functions. Now, let's go to qualified direct assault. When does direct assault become qualified? For both direct assault of the first and second form, the crime becomes qualified, meaning the penalty is increased when any of the following circumstances is present. Number one, when the assault is committed with a weapon. Number two, when the offender is a public officer or employee. Or number three, when the offender lays hands upon a person in authority. When you say weapon, it includes not only firearms, but also bladed weapons, clubs, or any sharp or blunt instrument used as a weapon. When you say public officer or employee, it refers to any public officer or employee for that matter. Hence, the offender can also be a PIA or an agent of a person in authority himself. And when you say lays hands upon a person in authority, the phrase is restrictive. Why? Because it will only be considered qualified direct assault when the offended party is a person in authority or when the offender lays hands upon a person in authority. There is no qualified direct assault if the offender lays hands upon an agent of a person in authority. Now, let's go to the complex crime of direct assault with murder or homicide or attempted or frustrated murder or homicide or serious or less serious physical injuries. What I mean to say is, when is direct assault complexed with another common crime or another felony in the Revised Penal Code? Let me give you an example. X, a policeman, arrested Y in a drug buy-bust operation. Z, Y's father, believing that his son was just framed up by the police, shot and killed X while the latter was on his way to the police station. Here, applying Article 48 of the Revised Penal Code, the complex crime of direct assault with murder is committed. If X survives the attack because of timely medical assistance, the crime will be direct assault with frustrated murder. Now, why do I say that the crime committed is a complex crime of direct assault with murder in that example? It is a complex crime because a compound crime results. And what is a compound crime? A compound crime happens when out of a single act, two or more grave or less grave felonies are produced. Okay? A compound crime results because the single act of shooting an agent of a person in authority or a person in authority results in the commission of two grave or less grave felonies. Take note that direct assault is a less grave felony. Why? Because the penalty for direct assault is a correctional penalty. When you say correctional penalty, when the penalty in its maximum is correctional, from arresto mayor to prison correctional. And murder is a grave felony because the penalty is considered as an afflictive penalty, as so provided in Article 9 of the Revised Penal Code as amended. There can also be a complex crime of direct assault with homicide, or direct assault with attempted or frustrated homicide, or direct assault with serious or less serious physical injuries, as the case may be. I am referring to that previous example I gave in the previous slide. Let's say X was not killed. Then the crime committed can only be direct assault with either attempted or frustrated murder or homicide, as the case may be. There is, however, no complex crime of direct assault with slight physical injuries because the latter will just be absorbed by the former. Slight physical injuries is merely a light felony. Hence, it cannot be complex. Again, please remember that for a complex crime to exist, the two or more felonies must either be grave or less grave. It can never, one of these felonies can never be a light felony. The combination must be either two grave felonies, two less grave felonies, or one grave felony and one less grave felony, but never a light felony.